Hey again, everyone. It's Rob Ryder, and today is Tuesday, June 8th, 2021. And today, from one Q to another. As it turns out, I have something in common with Q. So, making my national security dispute public to the NSA is the reason for doing this video, because I know that the NSA listens in to all the videos that I do. Of course, they keep track of everything that's happening on the internet, right? So it's all being recorded, da. So it's one of the reasons I do videos is to take the written word and read it into the record so that now there can be, an oral record of it. So anyways, I'm Staff Sergeant Robert Allen Rutluski, Army of the United States, and I am a Q clearance holder. If the people who left the military can continue to say that they have a top secret clearance, then because I worked in a nuclear power plant, and to do that you have to have a Q clearance, then I get to be a Q clearance holder. Now, why is that important? I don't even know if it is important, but it led to some stuff that is the reason for this video. So it was important to me. So hang on a second. So yesterday I'm going through my Gap stuff, and I see this posting comes up and it's got Q clearance on it. It's like, well, ain't that interesting? And I could barely read it, so then I went and got this version, which isn't that much better, but I can say, hey, this Department of Energy, I used to work there, right? And so I decided to read it. And since that's a little bit difficult to read for me, let's go to this. At the bottom, though, I talked about in popular culture, which is where I want to start at, because the QAnon conspiracy theory is named such because the 4chan poster, who in 2017 created the persona behind the conspiracy, claims to be an individual with a Q-level security clearance. Why ain't that something? That's why he called himself Q. He had a Q-level security clearance. Despite the overwhelming majority of the conspiratorial predictions never materializing, which were dense, jargon-heavy, nonsensical, self-contradictory, and contrary to known facts, which followers interpreted as a code to be cracked. As an online community sprouted up around QAnon's posts were disseminated by followers to other websites, drawing in more and more followers and launching YouTube channels, etc. Increasingly, QAnon has been booted from mainstream platforms, though it still thrives in some digital corners. Followers had a presence at the 2020 storming of the United States Capitol. Right? They didn't call it a riot. They're storming it. That's a big difference there. Good deal. That's probably written by Q himself. But anyways, what is this all about? So Q has a Q clearance. Now, what's a Q clearance? Well, a Q clearance authorization is the United States Department of Energy security clearance required to access top secret, restricted data, national security information, all this stuff, right? Covers nuclear weapons, related materials. The lower level L clearance is sufficient to access these other things, national security information, RFDs, which is secret, formally restricted data, confidential, restricted, so forth and so on. But that isn't the same as a Q. Formally restricted data, access to restricted data is only granted on need-to-know basis to personnel with appropriate clearances. A Q clearance is equivalent to the United States Department of Defense top secret clearance. The Q access authorization corresponds to the background investigation and administrative determination similar to what is completed by other agencies at top secret national security information access clearance, which, I remember, I had to go there and we had to get your security clearance. And I worked at Davis-Besse Nuclear Power Station. Well, there and North Anna. But, in Davis-Besse, I had access to the whole plant. Key card worked everywhere. So, if that's what it took, then I have a Q clearance. So anyone possessing an active Q clearance, so now the only thing is, well, is it still active or not? And I'm going to say it is until somebody says it isn't. And they can prove it, because I never got a letter saying they deactivated my Q clearance. So the day I left, I still had a clearance. So anyone possessing an active Q clearance is always categorized as holding a national security critical sensitive position. Well, go frickin' figure. I got a national security critical sensitive position. What's the pay rate for that? Because I ain't doing very well. Additionally, most Q-cleared incumbents will have collateral responsibilities, designating them as a Level 4 National Security Special Sensitive Personnel. Well, if for sure, then NSA would be listening in. With these two distinctions standing as highest risk sensitivity levels, occupants of these positions hold extraordinary accountability, having the potential to cause exceptional, grave, or inestimable damage to the national security of the United States. We're taking this shit real serious. All right, I got a Level 4 National Security Special Sensitive Personnel. I don't know what to tell you, man. That's what they gave me. So, as far as I'm concerned, I still have it. I got to go start complaining and see what I want to complain about. And I'm going to show you, I wrote this little petition to them because you can, right? It's one of the things you get to do against the Secretary of the Department of Energy, Jennifer middle initial Granholm, who used to be the governor of Michigan, right? Because she didn't take the oath to satisfy the 6th article of the Constitution. So she can't be the fucking secretary. There you go. Let's just start right there. Right? There's the crack in the doorway. Right? The door crack, step your foot in. Where are we now? So in addition to classification levels, 3 categories. Okay, employee must have security level clearance. So that's all good. Much of the DOE information at this level requires access to critical nuclear weapon design information. Well, I knew exactly everything there was to know about how nuclear power plants worked back in the day. So yeah, such information bears the page marking top secret. I don't remember seeing that stuff, but who knows? Who knows what I saw? DOE clearances apply for access specifically relating to atomic or nuclear-related materials. Restricted data under the Atomic Energy Act of 1954. The clearance is issued predominantly to non-military personnel. In 1946, the U.S. Army Counterintelligence Corps Major William L. Uana, in his capacity as the first chief of the Central Personnel Clearance Office of the newly formed Atomic Energy Commission, named and established the criteria for the Q clearance. And you can go, this guy's got quite the history behind this, William L. Uana. So, he was a counterintelligence guy, and he's setting up the program for Q clearances. Go figure. The security clearance process at DOE is adjudicated by the DOE Office of Hearings and Appeals, where an individual whose security clearance is at issue, Jennifer Granholm, may seek to appeal a security clearance decision to an administrative judge or subsequently to an appeal. Well, that's one way they could do it, or I could complain to them and say she doesn't have one, and then they have to do an investigation. So that's my angle. As a 1993, Q clearance is required a single scope background investigation of the previous 10 years, the applicant's life by both the Office of Personnel Management and Federal Bureau of Investigation. As of 2019, it cost $5,600. Well, there you are. So I say I still have a Q clearance. I never got a letter saying it had been rescinded or didn't do anything for it to be rescinded. I have one, and it's in my full legal name, but Jennifer middle initial Granholm doesn't. And she's the one claiming to be an officer of the United States, right? The Secretary of the Department of Energy. So she has to have taken the oath to satisfy the 6th article of the Constitution. That's a wonderful day. Okay, hang on. Let's go look at this DOE Office of Hearings and Appeals real quick. Okay, not that there's much to it, right? But I just, because I'm making public record, got to show these things. So this is the Department of Energy's website, and here's the Office of Hearings and Appeals, right? Information. It's a quasi-judicial arm of the Department of Energy. Well, there you go, man. You get to make the decision if the Secretary of the Department of Energy has to take an oath to satisfy the 6th article of the Constitution. Right? And so there was a couple ways to do this. One was, well, you have this Alternative Dispute Resolution Office. Where was that at? That was right here. So I decided, well, I'm just going to write a short petition, send it to this office here, tell them what's going on, and we'll see what they do with it. All right, so that's as far ahead as I had thought it before I did it and sent it, and now I'm waiting to see what happens. Right, all that happened this morning, so I'm waiting to see what happens next. I wanted to show something else, though. Hang on a second. One of the links in the Q article led to this page here talking about the Department of Energy security clearance process, right, where the DOE and the NRC maintain their own security clearance process as put into effect by the Atomic Energy Act of 1954. Right? They're separate from everybody else. As we have indicated in other articles, U.S. government security clearance process is not centralized. In addition to the security clearance process by the Department of Defense, which compromises most of the clearances, many federal agencies have their own specialized procedures for processing security clearance cases. The DOE and the NRC have their own process. Most federal agencies use similar language when discussing clearance levels. The most common terminology used to describe a clearance is confidential, secret, and top secret. The DOE is different. At the DOE, there are two types of security clearance, the L and the Q. The L clearance is similar to confidential and secret, and the E clearance is equivalent to top secret. But it didn't say anything about the Q. All right, I said L, so maybe they meant to have a Q here. Did I show that real quick? Let's look at that. They had a little chart on here. All right, so here's all the clearances, right? Confidential, secret, L, top secret, Q. Well, just by looking at it, it looks like, well, it looks to me like Q has access to things that top secret doesn't. It's got access to everything top secret does, and then access to things that top secret doesn't. So yeah, I really want to have my clearance still. I can get that all figured out here. So the security process is governed by some particular part, 10 CFR, Part 710. The criteria for determining eligibility for security clearance at DOE dictates that the agency must undertake a careful review of all of the relevant facts and circumstances and make common sense judgment after consideration of all relevant information. The following are the normal steps of security clearance review. All right, the first step in a security clearance review process is for security concerns to be identified in connection with the individuals holding the DOE clearance. Well, Jennifer Granholm isn't using her full legal name. That's a problem. The local director of the security will review the security issue, add issues, and either they will be resolved positively or be moved forward as a potential security clearance action, which could lead to access suspension. Well, that would be a wonderful day. That'd draw a line in the sand. The first step in the security clearance adjudication process is for the individual to be notified of potential security concerns regarding their security clearance. Hopefully they've contacted her already. The notice provided to an individual will state that the reliable information in possession of the DOE has created a substantial doubt concerning the individual's eligibility for access authorization. The individual can then ask the matter be resolved by the manager based on existing information or by seeking a personal appearance before an administrative judge. Or they may go to a FEMA camp. Just depends on how people feel that day. If elected, the next step in a DOE security clearance case is for the individual to present their case before an administrative judge of the Department of Defense Office of Hearings and Appeals, during which hearing the individual has the right to be represented by counsel and to present documents, witnesses, and other evidence to support and maintain security clearance. The hearing will be transcribed and administrative judge will issue a decision. If the administrative judge manager's decision is not the individual's favor, the individual can then appeal the decision to the DOE Office of Hearings and Appeals. The appeal process consists of 3 members of and reviews all appeals. The appeal panel will make a decision on the appeal, and the individual will be notified. If a final negative decision has been issued, the individual may subsequently appeal for reconsideration at a later date. When an individual is facing security clearance issues at the DOE, NRC, or before another agency, it is important to obtain legal advice and potential representation. Well, Granholm, she's an attorney. She can't represent herself. Sorry, you're going to have to go hire an attorney. Okay, so there you are, right? That's a big deal. Security clearance for the Department of Energy is not something that's played around with. So let's go look and see who is the current secretary. Hang on a second. Okay, United States Secretary of Energy is the head of the United States Department of Energy, a member of the Cabinet of the United States, and the 15th in the presidential line of succession. And the incumbent is apparently this Jennifer Granholm, who she used to be the governor of Michigan. In fact, she's the one that sent all the businesses out of our state back when she was the governor. Right, all that shit went to Mexico. We'll replace it with something sometime. Right? That was going to be her successor's problem, not hers. Her part was to get rid of all the jobs. Well, there you go. Now she's got another job. Now she wants to be the head of the United States Department of Energy. Well, sister, you don't have proper oath of office. So I'm going to try to put you in jail. How you like that? Okay, and so, it's not that hard to do once you figure out where you can do it at. On the ADR website, they gave the address of the ADR office, Alternative Dispute Resolution, right? So I just put on my official persona, Staff Sergeant Robert Allen Radlewski, Army, United States. That is my Social Security number, and I am a Q clearance holder. Somebody got to tell me I'm not, and then they got to prove it. And because I am, I have a duty to do what I'm doing. So, thank you, Jesus. Thank you for the frickin' finally explaining to me why I went and did all those things through my whole life. Okay, Jennifer M. Granholm, that's her middle initial, M, is impersonating as Secretary of Energy and Executive Officer of the United States. 1. Jennifer M. Granholm is not the full legal name of a citizen of the United States. 2. Jennifer M. Granholm did not execute the oath to support this Constitution as required by the 6th Article of the Constitution of the United States. 3. Jennifer M. Granholm, registration number P40922, is a Crown agent registered with the State Bar of Michigan. She's a frickin' Esquire. Right? The Secretary of Energy is an executive office of the United States whose incumbent must execute the oath that satisfies the 6th Article of the Constitution of the United States. An act to regulate the time and manner of administering certain oaths, that'd be the old one, Stat 23, was the first law passed by the United States Congress after the ratification of the U.S. Constitution and signed by President George Washington on June 1st, 1789. I attached a copy for him. 1 Stat 23 contains the form of oath the Secretary of Energy must execute, which is simply, I state your name, do solemnly swear or affirm that I will support the Constitution of the United States. This form of oath requires the incumbent's identification be inserted into the form, that'd be where the AB is, as a condition of proper execution. There is no record of birth, state identification, real ID compliant driver's license, military identification, nuclear power plant ID issued in the name Jennifer M. Granholm. Esquire, Jennifer M. Granholm, is registered, registration number P40922, Crown Agent member of the State Bar of Michigan Association, who abdicated her First Amendment rights as a condition to join this association that advocates the overthrow of our constitutional form of government. Right? The State Bar of Michigan makes attorneys give up their First Amendment rights, right to free speech, to be members. And therefore, they're saying, well, we don't agree with your Constitution. Because if you don't agree with one part, you don't agree with the whole part. So back to the petition. The use of the alias Jennifer M. Granholm to gain access to a class of office listed in the 6th Article of the Constitution of the United States is the act of a spy, and the omission of a loyalty oath required by the sovereign power is a common law act of treason. Has been since at least the time of Henry VIII. Jennifer M. Granholm and others concealing their true identity and impersonating as incumbents of classes of officers required by the 6th Article of the Constitution of the United States to execute an oath of office to support the Constitution are using their position to spy on the United States and aid its enemies. Jennifer M. Granholm and her conspirators must be stripped of authority and imprisoned for war crimes, which I declared, under penalty of perjury, that the foregoing is true and correct. Right? Because according to these people, I got some heavy-duty duties to do. Anyone possessing an active Q clearance is always categorized as holding national security critical sensitive position. Additionally, most Q-cleared incumbents will have collateral responsibilities, designating them as Level 4 National Security Special Sensitive Personnel. With these two designations standing as the highest risk sensitivity levels, occupants of these positions hold extraordinary accountability, having the potential to cause exceptional, grave, and inestimable damage to the national security of the United States. Well, I don't want that to be me, so I got to go narc on her. Sorry, Granholm, you got to go. Okay, so just in closing, because I mentioned one stat 23, I like to show where it came from, right? This is out of the statutes at large. It's the very first law passed after the ratification of the Constitution. Right, we're said in the very first section that the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the following form, to wit, right, I, A, B, solemnly swear or affirm that I will support the Constitution of the United States. Now, when it says shall be administered in the form following, to wit, you can't change the way that it looks. Right, that's how it has to be. You have to put your name after the word I. And when they pretend to take the oath in Michigan, for Michigan, it doesn't have any place to put your name in there, so that isn't the proper one. They can't say, well, I did take an oath. No, they have to take this oath. Right? And, I've shown this many times, but I just need to show it as often as I can so that it gets ingrained in people's heads, right? That in Title IV of the United States Code, Section 101, right, every member of the state legislature and every executive or judicial officer of the state shall, before he proceeds to execute the duties of his office, take an oath of the following form, to wit. Hey, it's the same oath. Because, according to the 6th Article, all these people need to take proper oath of office. All right, this little clause right here, that the senators and representatives before mentioned and the members of the several state legislatures and all executive, that'd be Granholm, and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. And no religious test shall ever be required as a condition or as a qualification of any office or public trust. Any office or public trust under the United States. It's pretty clear they got to do it, and they're not doing it. And the oath that was written to do that, right? So they write the Constitution, then the very first law that they're going to write is, to put some meat on the bones of the skeleton of the Constitution is, here's the oath that satisfies the 6th Article. Well, it also includes state officers. And, eventually they got around to, putting that part into the United States Code under 4 U.S.C. 101. Then it goes on in 102 and says, such oath may be administered by any person who, by law of the state, is authorized to administer the oath of office. And the person so administering such oath shall cause a record or certificate thereof to be made in the same manner as by law of the state, he is directed to record or certify the oath of office. So where's the freaking copy of the oath? Right? If they can't show it to you, it didn't happen. And they can't show it to you because it didn't happen. So there's no judges in your state that have taken this oath. Your governor hasn't taken the oath. The attorney general hasn't taken the oath. County commissioners haven't taken the oath. None of these people have taken this oath. Right? Anybody who would have to take the oath that's in your state's constitution has to take this oath also, because the federal republic is superior to the political state. Every state was guaranteed a Republican form of government, and that's the federal republic, one nation under God, indivisible, liberty and justice for all, with a common law. That would be federal law. Right? Not all these fucking 50 different states that want to do it their own way, and then they're not even the ones doing it because they've vacated the state and created a free association under Article 1, or under the First Amendment, right? That's where the United States of America is. That's not in the United States at all. It's, it's a foreign entity in the United States, but it's not the United States. And you don't have to be a member of it, but they've coerced us all to be members, and they use whatever tactic they need so that everything looks like we're their voluntary member of their frickin' jurisdiction. Well, that's the political state, right? But that isn't the republic, federal republic, which is supposed to have officers enforcing the law. So, Granholm didn't follow the law. She can't be the secretary. You can say that about any secretary on Biden's board. You can say it about Biden. You can say it about Harris. None of these people have taken an oath to satisfy the 6th article of the Constitution. Even the President of the United States of America, which is the office talked about in Article 2, that Biden was supposed to take an oath to, it says in his oath in Article 2, it doesn't say anything about supporting the Constitution. It says protect and defend. And the 6th article says you have to take an oath to support if you're going to be an executive officer. Well, that's the president. So he needs to take 2 oaths. That's how it's supposed to work. But right now, none of this is working. And, I'm going to shine a light on it. So yeah, that's what I did today. I sent a little complaint to a petition for redress of grievances. Call it what you want. To the Department of Energy, saying their secretary is an impersonator. She's an imposter. She has to go. And once one domino falls, well, that would get them all going. So stay tuned for more. We'll see what happens. Okay, you all have a great day.